very quick. Thank you very much for settling down. I know that some of you are coming back from classes, so thank you for coming on time. I'm Kim Goff-Cruz. I'm the Vice President for Student Life, and it is my pleasure as we celebrate the Constitution this week to be able to invite those of you in the audience and those of you who are watching the live stream to a very special conversation with Supreme Court Justice Stephen Breyer, with our own Margie Marshall, who is the Yale Corporation Senior Fellow, and of course with Yale President Peter Salovey. So welcome. Justice Breyer's wisdom, as we all know, is about Constitution was quite broad and has had a significant impact on the court's work, providing timeless principles for situations which, of course, those who created the Constitution did not imagine at the time. And so we are particularly grateful as he's here with us to welcome him back not only to Yale, but to also thank him particularly for the time that you're going to spend with students today and making them a priority during your visit. Now, those of you who know Chief Justice Marshall, that she brings her own expertise to this conversation. She is the former Chief Justice of the Massachusetts Supreme Judicial Court, as also a defender of human rights both in South Africa and the United States, a longtime university leader, and of course, most importantly, a graduate of the Yale Law School. So we want to welcome her back. And of course, President Salovey, who needs no other introduction other than the fact that he is our esteemed leader, and today he will serve as moderator for the panel. Now, before we start, I'm going to ask all of you in the audience to please silence your personal electronic devices. We'll take a moment for you to do that. Thank you so much. And with that, I'm going to turn over the panel to Chief Justice Marshall.
Thank you very much, Kim. And welcome to all of you. It is wonderful to see such a packed house, really wonderful. And Kim said yesterday was the anniversary of the Constitution. That's the United States Constitution. And it's 227 years old. And while on the subject of age, when I graduated from the law school, that's this one, Justice Breyer, 40-something years ago, well, not quite, almost as old as the Constitution, there were no classes on global constitutionalism. There were no classes on human rights. And it's taken a great deal to have that become such a central focus of this law school. Part of that, of course, is because of our amazing faculty, Dean Robert Post, who's younger than I am, a lot, Professor Leva Siegel, and Judith Resnick, who I don't see at the moment. Oh, there, you're sitting right next to, and who's a lot younger than I am. But it's also, it just is wonderful because of what's happened around the world. And of course, she doesn't want me to thank her, but I just want to mention that this is the Gruber Program for Global Constitutionalism and Women's Rights. And so I'm delighted to say that we are part of really a fabulous international movement. So I think what most of the students here want to know, Justice Breyer, is how do you become a Supreme Court Justice? Mm-hmm. Okay. So I'm going to give you some hints, just looking at what he did to become a justice. First of all, you have to be fluent if you are native-born in the United States in at least one other language other than Latin. So for those of you who don't speak fluently another language, forget it. Fortunately, Justice Breyer is fluent in French. He always told me he was. And last night, when I heard him talking in French, I can't really tell how good your accent is, but you were pretty good. At least it sounded to me. At least the person to whom you were talking wasn't wincing, right? The second is you have to be a great public servant. You can't start your life wanting to be a justice of the Supreme Court. At least I'm hoping you didn't start your life that way. But Justice Breyer, as you probably know, has worked in all three branches of our government. All three branches are responsible for the Constitution, not just justice and justices. And he has worked, obviously, in the judiciary, first as a law clerk on the United States Supreme Court, as a law professor, which might be an impediment, in the executive branch, and most important, in the legislative branch. where he was counsel to the Senate Judicial Committee, working for one of Massachusetts' great senators, Senator Edward M. Kennedy. Justice Breyer is a teacher, a great teacher. That is different from being a scholar and an academic. He loves to teach. And we hope that today you will think of him as a teacher so that you can ask him the questions that you want to ask him about anything. He will tell you if he can't answer the question, but we don't protect him, and so you can ask him anything, and he can decide whether or not he wants to answer it. So, Justice Breyer, it is just one day after the anniversary of the Constitution. What should this group of students, their friends, their colleagues, know about the United States Constitution? What should they think about? How should they look at it? Should they bother with it? Is it important? What should they know?
Yes.
And the follow-up question is why?
You know about the Constitution. Now, you've gotten a whole lot of things in that. First of all, you gave me a very nice introduction, which I appreciate. I could return that introduction, and I will tell you, between helping people lead decent, fair lives in actual result and having it come through, I hate to say between the two of us who's done more, but I'll tell you it isn't me. And also, I'd point out that the three great mistakes people make about the Supreme Court, I can only say the first one. The others will come up. But the first one is they don't understand that law in the United States is made in the states. 95, 96, 97%. Don't forget that. All family law, state. Education law, state. Criminal law, state. Business law, state. Even environment, state. So when I talk to this group, which is a great chance for me, because you're just the group I want to talk to, I say the first thing that I'd like you to have in mind is you want to make a difference to other people's lives. Don't forget, if you're a lawyer or connected with law, that city council and this, by the way, I've given this speech before. Come to think of it, he just reminded me. At Yale, they had a group of Chinese professors who were visiting, and lawyers, Chinese lawyers, judges. So we were talking. I give the same speech. I often give the same speech many times. But the point is, as I said, where is the law made that affects you here? And I had a hesitation. I was thinking, what's the capital? Hartford. Okay, got it. Hartford, not Washington, D.C. Washington, D.C., they get their names in the paper. That's because the journalists are down there and they don't like to move, and so they. But here, Hartford is the place, if not the city council. Okay, so at the end of the 2 days, one of the Chinese lawyers says, they had questions. Yes, I have one question. Says, why do they make all the law in the United States at Harvard? Okay. So anyway, you get the point. That was another point you brought up. That didn't pass me by, that snide remark about the Harvard Law School, where I taught for many years and was a student. But for 18 years, I've come to this seminar here, so I've learned something. And I'm not going to say a word about the fact that at Harvard, people talk about Yale. They say it's an acronym for Youth Against Law and Education. But you're back to the Constitution, and this is the document. And one of the things we do, because we also interpret federal statutes, and we don't deal with state law. We deal with law in our court made by Congress, federal administrative agencies, and this document, the Constitution of the United States. And that's the document. Well, there are many things I'd like you to know about it. But I'll start with one. What is it about? What does it do? It's good to start there. Not too hard. Just say it, not in one word or two, but not in a million either. It has a system. It has a framework for a government. What kind of a government? A kind of democracy. What kind of democracy? A democracy that has institutions that give power to the people to say what kind of state, federal, local, or other organization they want their community to be in, to what they want, what laws they want. It's the people's job, not the judge's job. But It is the kind of democracy that protects basic human rights. They're listed mostly in the Bill of Rights. The structure's in the first 7 articles. Bill of Rights, basic human rights, a degree of equality, that's the 14th Amendment, a separation of government power vertically and horizontally. Vertically, states federal, horizontally 3 branches, so that no single group of government people can become too powerful, and that insists upon a rule of law. So you say those 5 things, you say democracy, human rights, equality, separation of powers and the division of powers, and rule of law. You've got the heart of it. That's it. That's not too hard to remember. You can even remember that for a quiz tomorrow. And once you have that, fill in the rest with the details. But all 9 of us, I think, will agree upon that general description. Now, why are we celebrating this today? Not too many people do celebrate it. But why? And she's part of it, just as much as we are in the Supreme Court. It is a rule of law. What does that basically mean? It means for 200 years or more, people in the United States, originally 4 million, today 310 million, have, with all kinds of ups and downs, learned how to live together under the rule of law and come into the courts, hers, mine, others, and their basic differences are often, not always, but often resolved under this document and other statutes, not in the streets with fists, guns, and knives. You say, that's such a simple idea, everybody knows that. Good. I'm glad you do. And I hope you remember it, because 310 million or 320 million have been held together. What about the future? I don't know. That's yours, okay? That's in 2 sentences why I think it's important, which was your question.
It was.
Thank you.
Mr. President, I just don't think that you should take that description of Yale, so why don't you just ask the next
Sure.
question?
First of all, let me thank you all also for joining us today, and let me thank Justice Breyer for being willing to put up with something that we love to do with people who have a long association with Harvard, and that is to sit them in front of a backdrop that says Yale in multiple colors about 40 times. Let me ask a follow-up to that question, and that is, as you took out that Constitution from your pocket, is there something distinctly American about that document?
Well, that's a good question. If you go back, you see it reflects the ideals of the French Enlightenment, the Scottish Enlightenment. But if I were to pick out one thing, which is a little esoteric, but I think important, and you probe into the thought of an American, you're more likely to find this. It's something that Madison said. He said that this document is a charter of liberty decreed by power. Now, let me put it the other way. A charter of power, see, that's too bad, there we are. It was a really good phrase I was about to say, and I just mucked it up completely by getting it backwards. Don't do that. Wipe that out. It is a charter of power decreed by liberty, not a charter of liberty decreed by power. Now, that's wonderful because nobody knows what it means. What it means is basically this. In Europe, there's a king at that time. But still, even when there isn't, power flows from a central authority. Now, that central authority, which has residual power, may well decree liberty so that people are very much free. But in the United States, the individual is free and gave power to the central government. So if it isn't here, they don't have it. And the residual is back in the people. Now, why do I think that's so important? I think it is uniquely American, and I think it is pretty important. When somebody asks, as they often will ask me, why don't you belong to more international courts? I tell them that. And I say, look at the judges in the United States who appointed you. I think it was Weld.
It was Republican
Yes,
Governor
governor,
Weld.
elected. Who appointed me? Oh, that's another thing you got into appointments. That's a different story. The main characteristic of a person who's appointed is he's lucky. But elected.
Official.
President Clinton, President Carter, elected. You see? There's a line of responsibility back through an elected authority to the people. And that matters to people. That matters. They may go too far in many of the states when they elect judges. But that line of legitimacy traced back to the people does matter and has mattered for 200 years. And there is a tendency, which I don't really think it should be determinative, but there is a tendency to say, but who are those people over there, those judges? They weren't elected. And moreover, there's no tracking it back to me. You say it comes from a treaty, but that's pretty far, pretty distant. And if we're going to overcome that, we have to have reasons. We have to explain it. We have to be careful. We have to make certain that they're willing to accept it. But that is American, I think, and I can understand it. And it's not wholly a bad thing. It has its pluses and minuses.
So let me just ask you a couple of questions. One of the things that, and I look to this group of young people, you've just heard Justice Breyer say it's fundamental appointment process, the federal bench, the Massachusetts bench, is through an elective process. There's some accountability. It's an elected official. And yet, so often we see that power of the president not inform discussions and debates about who should be the next president, who should be the next governor. Why do you think that is? I mean, people care a lot about the United States Supreme Court. It's headline.
Not a big election issue.
No,
I don't
not.
think. I was told that, but do you think? You agree?
No, it's not an election issue.
Not an election.
And yet,
Technical, not in the newspaper every day, I'm glad to say. The interest to lawyers, of interest to law students, interest to certain interest groups within parties.
right.
Very much so. But broadly, I mean, I've had a lot of people who know politics tell me that election is not going to turn, rise or fall on the Supreme Court of the United States. Now, that may no longer be true. I don't know. What do you think? I mean, you've seen the same thing in Massachusetts.
I don't think it does. And to some extent, there's part of me that says I'm delighted that it does.
Yeah, me too.
That it really doesn't. In any case, so there is an exceptionalism to American constitutionalism, and yet here we are talking about global constitutionalism, and I think, our history is we are cautious about other courts, international courts. We have treaties. There's a kind of tension between talking to, thinking about, engaging in, citing, footnoting. Well, you don't footnote, so that's okay. Is that a conversation? Is that looking for guidance? Is that looking for precedents? If we've got great courts all over the world now that have, liberty, constitutions, free speech, they may have a different structure of government. Helpful or not helpful to engage in those conversations?
No, you're helpful.
Because?
A lot of reasons. When you may learn something. That's the main reason. And often you do. Often I do. Another reason depends on what court, because as we're getting now to what I think, and probably you think, is a pretty important question. People don't care that much about the judges in elections, do they, when they're electing the president? Not really. Some do and so forth, but not that many. Right. They're not very familiar with what judges do.
Agreed.
But, and you say, well, that's sort of surprising, because we do some things that are pretty unpopular.
You do, I don't.
Oh, yeah, you don't. You don't, don't you? You don't. Now, and they affect people.
Oh, yes.
So that's the question, that, why? Why is it? And I get this all the time, and I'm sure you did too. You do. why do 310 million people do what we say? Why do 6 million people in Massachusetts do what you say? Why? I mean, we, have no weapons, etc. And I get that question. The president of the Supreme Court of Ghana 2 years ago, she put it so well, and she's really trying to make reforms in Ghana. Why do they do it? See, that is a big question, and an important question. And they didn't always. How long do you want me to go on with this answer?
Oh, this is good. Let me follow up.
Let's break it into parts.
Let me follow up the beginning part of Justice Marshall's question, which seemed to be asking how much should American justices, judges rely on, refer to, think about the reasoning of justices from other countries. I know you've written a little bit about this and debated it with others, but...
And the reason why I ask is not to get into the sort of debate, but it's because I look at this group of people who come from all over the world. They know their systems. They come here. It's a wonderful law school. We are delighted to have them. And we're training lawyers and undergraduates and everybody else to think about, they operate in a system. When I came from South Africa, there was no internet. It wasn't possible for me to read judgments or decisions, of the German Constitutional Court, except with great difficulty. They weren't translated, and so on and so forth. This is a generation of people who don't think nationally. They think, in many cases, and so I think they find it a rather odd question that there should be perceived limitations. Where's the role of nation courts in a sort of global environment?
All right, let's do that. I'll give you one example. You can give me another. This is a political debate.
Right.
It's not a legal debate. I am with a congressman, good congressman, at a meeting. We sometimes have a judge, have a congressman, now have a couple of law professors, and this subject comes up.
Of course.
And he launches into this, why are you referring to decisions of courts of other countries? So they're not elected because they're stupid, they're not. And I said, I guess that, I fall right. I said, I guess that's aimed at me, because I have. He says, yes, it is. So I say, well, let me tell you the reason that I do is more and more nations in the world have constitutions like ours. They try to protect democracy, basic rights. More and more have judicial systems like ours. This is a means to help enforce those constitutions. And problems become more and more similar across the world. So if I have a person in a profession like mine, interpreting a document like mine, in the face of a problem like mine, why don't I read what he says? I'm not bound to follow it. I might learn something. I thought, that's a really good answer, isn't it? Yeah, he said, okay, read it. He says, just don't refer to it in your opinion. Okay. Not knowing enough to shut up, I continue and say, yes, but you see, there are many courts that are new in this game. Eastern Europe, comparatively so. Other places they're trying to establish it. They refer to our decisions. If we refer to theirs when it's relevant, not saying it's binding, but just saying that, it was helpful or not helpful. They can go to their legislators and say, look, what we're doing is an important thing, and it's recognized elsewhere in the world as such, and that helps us. He says, that's fine. Write them a letter. Okay. So I can give a lot of good reasons why we should do it. We might learn something, we might be helpful to others, etc. But where he's coming from, those answers are not going to be satisfactory. And it isn't just pure isolationism. It is that which you first brought up. It is that which is, add to that suspicion that all the judges think alike politically, and so they're going to decide the same thing, and they'll be in. No, but put it in better terms. Put it in terms that's fair to his argument. What he's worried about, and many are, is that our, quote, uniquely American, or originally American, or American as copied abroad, or American is descended and we copied it. But those things about that I mentioned, those 5 things in the Constitution, that they'll somehow disappear, that they'll somehow be watered down, that they'll somehow not be as strong as they were, that our American features that we admire in this Constitution will become merged into some kind of general we know not what. That, I think, is the underlying fear. You've seen that as well. So therefore, I'm trying to work on something which will show, let me tell you why that question, your concern, is not relevant today. It's not that it's wrong. It's just that it's not relevant. That we live in a world where if you look at our docket, you will see that we have cases, constitutional cases, treaty interpretation cases, statutory cases, where you cannot decide it properly unless you know something about decisions, legal practices, other practices, the world outside the United States. Now, I'm going to show that to you, and I'm going to show you what they're about, and I'm going to show you what kind of questions they raise. And when you see the nature of those questions, I hope that you will come to the conclusion that the only way to preserve our American, if you like, values, which are now widely shared, the 5 that I mentioned, and perhaps others, is to know more, not less, about what goes on abroad, and to refer to it in decisions, not because it's necessarily binding, but because then other people know transparently the basis upon which you're deciding and can criticize, praise, or blame as they wish so that the law advances. That's the whole argument.
And President Salovey, you teach not law. Does it make a difference to you that you sit at the top of a great institution? I mean, have you seen similar kinds of changes? Are there things that you would like your students to learn from Justice Breyer?
Well, that's a great set of questions. I will say one thing that has changed in just the years that I've been at Yale, relevant to this last topic. I'm a psychologist. I taught introductory psychology for many years in this room. And in 1986, when I first started teaching, the reference to studies done anywhere else in the world, the reference to theories that had grown up anywhere else in the world, the reference to findings from cultures other than dominant culture in America, were very few and far between. There was almost no interest. In fact, there was this very bizarre logic that that created noise in whatever we were thinking. That was adding error. That completely switched over the 25 years, and now to only look at findings that are local, to only look at theories that are homegrown, would be considered limiting, that your theories don't generalize, they're not externally valid. There's no generalizability of what you're saying. And I just watched this shift in my field. Maybe my field was late to this, maybe not. But it was really this same question. People went from deep suspicion in one direction to deep suspicion in another. Let me ask a little bit different question, though, in a different direction. Last night, several of us were lucky enough to have dinner with Justice Breyer, and the conversation we were having around our table was whether decisions of the court could push society in new directions, change public opinion, motivate social movement, motivate great opinion shift, both of these justices having been involved in cases that were of great consequence to our social lives, or whether that's not the role for even to be thinking about for the court. It doesn't really happen. The court is reflecting larger changes in society that might be evolving anyway. And we were talking a little bit about Brown, and we were talking about gay marriage. We're talking about, what is it, reflection or is it motivation? Is it the push or is it the reflection? And I guess what I'm asking is, at least with respect to the judiciary, can state ways change folk ways?
The obvious example of that was Brown, which is of great interest for another reason. I want Margie to say, look, the big question for everybody here, just as much as for me and for Margie and for the president here, is go back. Why do people follow this? I mean, Brown told them they couldn't segregate anymore. Why'd they do it? They felt pretty strongly in the South about segregation. They liked it. Well, I mean, some liked it. I mean, perhaps. All right, you see the point. Mm-hmm. Now, tell them, Margie knows this. I mean, it was South Africa that faced this same question. You know, they have a court. It's an excellent court. There are people going to do it. Now, we've talked enough so you see what the it is. It are cases, of which there are plenty, too many perhaps, but they're important to people. They make a difference in their lives. That's what you're talking about. Mm-hmm. They're pretty controversial, not popular, at least in some quarters. And they could be wrong. What about Bush v. Gore? I wrote a dissent, so but okay. So will people follow it?
South Africa?
Who is the key to that? I've heard you talk about him.
So the justice is talking about South Africa post-1994 with a wonderful new constitution,
Yeah.
Bill of Rights, and Nelson Mandela is the president, putative president, and he's the head of the African National Congress, and he's trying to get support across the country. There's one part of South Africa which is not so African National Congress. And there was a decision made by the local ANC parliament about how to allocate political power in the Cape area. And there was a challenge that was inconsistent with the requirements of the Constitution, and they went to court. And the Constitutional Court said, excuse me, you got it wrong. Okay? This is Nelson Mandela. This is the court telling this revered figure, you got it wrong. You got it wrong. I can't think of the functional equivalent except Bush against Gore. You know, people felt pretty strongly that they get it wrong, right? And Nelson Mandela, the next morning, went out on the steps of Parliament and said, this is a victory for all South Africans. Today, our new government shows that it doesn't matter how powerful you are subject to this. I wish I had the South African Constitution. I actually am an American citizen, so I carry around the same Constitution. It's a little book, a little longer, but essentially has the same principles. And he was telling his party, he was telling the people of South Africa, we have a new system, and he was most important, making a point about power, that there is a limit to power. There's a footnote.
Yeah, because we discussed this once before in a panel, and Margie didn't know that, and I didn't know what she was saying there. I wasn't there, but I was at the 10th anniversary of the court in South Africa. Mm-hmm. And at that time, Mr. Mbeki was the president, and the judges and the lawyers there were a little uncertain about how would he have said the same thing.
Right.
See? And they were a little uncertain about how he was going to react in terms of enforcing a decision of the Supreme Court, the Constitutional Court, that he didn't like. And he gave a talk, it was fine. And then we had a dinner, and at the dinner celebrating, it's a beautiful courthouse, and it was in the courthouse, and it's right on the site of the old jail where they put the apartheid demonstrators, you know, the anti-apartheid people and so forth. And in this dinner, suddenly by surprise, sort of at the end, lots of tables in the room, in comes Mr. Mandela. And if you've ever seen him, you know, beaming, I mean, unbelievable charm and unbelievable, I mean, just attraction. And he gets up and he tells that story. You could hear the sighs of relief in the room. Mr. Mbeki was right in front of him. Who is he talking to? Yes, Mr. Mbeki. You see, and that's the question that the president of the court in Ghana is asking. And I like to put it, because I wrote about this, I put it in terms of Hotspur's question. I said, great. You know, in Henry IV, you have Owen Glendower, who is a mystic, because he's Welsh. All Welshmen in Shakespeare are mystics. And Owen Glendower says, I can summon demons from the vasty deep. And Hotspur, your practical Englishman, says, well, so can I, so can any man, but will they come when you do call for them? That's the question. And it's a question that Hamilton doesn't write about. And that's her question. And my answer to that is I can just tell you about 2 or 3 stories briefly, and I tell her about the story of the Cherokee Indians in the 1830s, who owned northern Georgia. How do we know that? The treaty said that. Of course, gold was discovered, and the Georgians said, well, why should the Indians have the gold? After all, they're just Indians. We should have it. And so they took it. And the Georgians, the Indians being a highly civilized group, hired a lawyer, the best lawyer of his day, Willard Wirt, who eventually got the Supreme Court to say, of course it belongs to the Indians, the Cherokees. At which point you probably have heard, or may have heard, Andrew Jackson, the president's famous comment, supposedly, John Marshall has made his decision, now let him enforce it. And Jackson sent troops to Georgia, but not to enforce the decision, rather to drive the Indians to Oklahoma, where they went over the Trail of Tears, because so many died on the way, and they're still there. You see? And that wasn't that long ago was history. And then we go forward in history. And the most important case to me, I told that to a Russian paratrooper who was sent to our court by the State Department about 15 years ago, because he'd been in charge of pointing missiles in the United States. And they changed direction. And state said, we got to be nice to this man. All right, so I said, show him the Supreme Court. Fine, I showed him. And I said, what's your favorite case? I said, well, Brown is an important case in this century, perhaps the most important, but my favorite, Cooper versus Aaron. Why? Because what happened after Brown, 1954? Nothing. 1955? Nothing. Well, close to nothing. 1956? Nothing. 57? Next to nothing. Well, a judge in Little Rock says, go integrate Central High. Do it. September. Yeah. But Governor Faubus said no. And on the day those 9, the Little Rock 9, and this is what's terrible, is I'm annoyed at this, you see. I went to a meeting at Harvard, don't say it wasn't Yale, but it wasn't, it was Harvard, where 4 of the Little Rock 9 are there, only a year ago. And it wasn't much of an audience. They're heroes, those 9. They're heroes. And they walked, and Faubus said, I have the police, that judge doesn't. Out. And there were mobs in front of the school. And people we can remember, I remember that. The press was there across the world. And there they were, and there was a picture of Elizabeth Eckford, who is reading her book and being turned away with a girl in the background, Helen Bryant. And her face is contorted with rage at the thought of a black student going into that white school. And everyone saw that in the world. And what would Eisenhower do? And he was told by Jimmy Burns, governor of North Carolina, a moderate on race and former member of the Supreme Court. He quit during World War II to help run the war effort. But he said to Eisenhower, if you send troops, you better be prepared for a second Reconstruction. Are you prepared? You'll have to occupy the South. But Herbert Brownell, his wise counselor, said, do it, you've got to do it. And within a matter of 2 or 3 days, Eisenhower made up his mind, went on television, radio, I can't remember then. But he said, the 101st Airborne, 1,000 paratroopers, flew from Fort Bragg into Little Rock. And everyone in 1957 knew who the 101st were. They were the heroes of Normandy. Their parachutes had gotten caught in those steeples where they were shot. They were the heroes of the Battle of the Bulge, and he knew what he was doing, Eisenhower, by sending them into Little Rock. And they took those black children and they walked with them into that white school. And that was a great day. It was a great day for the law. It was a great day for the cause of equality, and it was a great day for the United States of America. And I'd say, I wish I could end the story there. But I can't. because along the little talk, they closed the high school, they tried alternatives, they went back up to the Supreme Court where all 9 said integrate, and you have to. We order it, but they were 9. And so the governor closed the school. But he couldn't make it stick. Too much had gone over, too much water had flowed over that bridge. And we have the Freedom Riders, and we have Martin Luther King, and we have all the different events that took place in the 60s. And now with all of that, with the court helping, but not determining, integration gradually came about in the South. And I say, I want her to know that story and memorize it. Because now when we have, you said Bush v. Gore was one of the decisions I'm talking about. What? Affects people. Unpopular with at least half the country, maybe a little more than half the country, but still unpopular, and in my opinion, wrong. But I've heard Harry Reid say about that the most remarkable thing about it is never remarked there were no riots in the streets. There were no guns fired. And when I talk to a group of students, I bring that up and I say, I know perfectly well 20% of you are thinking, at least 20%, too bad there weren't a few riots. I said, well, if that's what you're tempted to think, turn on the television set and see how and what happens in countries where they don't appear before the court of law and aren't prepared to follow decisions that are unpopular, that may be harmful and could be wrong. Well, you see, you can't have it both ways. And we've gradually, over a long period of time, come to the place where people will follow it. And that, to me, is a great treasure. But what I'm telling to her is, you want that to happen in your country, don't just talk to the judges. Don't just talk to the lawyers. Contrary to popular belief, there are 310 million out of 311 million Americans who are not lawyers. They're the ones you have to convince. So find ways of getting to the people in the villages. Because what you have to convince them of is that it is in their interest to follow a system where they will, from time to time, have important decisions affecting their lives that they don't like at all and that may even be wrong. By the way, this institution does not respond to politics. I mean, only very generally.
You're talking about your institution.
Yeah, I'm talking about judges. You're talking about Massachusetts. I'm talking about the United States. Elections, we say don't turn on it.
No.
And I don't know where they do. They might some places, but rarely. You see? Now, that's a tough assignment. That is a tough assignment. But naturally, being a judge, I think it's an important one. And it being Constitution Day, you see what I'll say to the students is, well, there we have it, and we think we've got this problem solved. No, we don't. We've had it solved in the past, to a degree, for my generation up to a point, but it's up to you, you say. And if I want to go on with my 4th of July speech, I tell the students this, I'll say, well, I can't tell you how to lead your lives. And I surely can't. I hope that you'll have a profession. I hope you will find someone to love. I hope that you will participate in your community's life. And that could be the library board, if you like. Or it could be politics. Or it could be voting. And I can't tell you more than my hopes. But I can tell you one thing, I do know something, not a lot, but something about this document, and the people who wrote it will say, if you are not going to participate in public life, this won't work. And so what I think we can do the most, I like Derek Bach, actually, bringing in Harvard. He found a pretty good quote, which he says comes from, I think, Thucydides. Or no, it's Pericles, who's giving the great funeral oration.
I'm delighted either way.
No, it's an important thing. And I don't know if it's really true, but I think he says this. He says, Derek says, he says, look, he's talking about the virtues of Athens. And he says, in Athens, what do we say of a man who does not participate in public life? We do not say, there is a man who minds his own business. We say, there is a man who has no business here. Pretty tough. But I think you want to get into the minds of the framers? That's what they're assuming. That's what they're assuming. And that's why Madison is writing about ancient Greece. And that's why they're looking all over the world for models of democracy. And that's why eventually they wrote this Constitution, where power would flow from a participating public. And that, I think, is the most important thing that we can talk about and think about on Constitution Day.
Thanks.
Wonderful.
So I think the time has come to shift to your questions. And I was given a small stack of cards here, but if someone had a question, oh, there's more coming in? No, okay. If someone had a question that wasn't submitted, feel free to hand it to me here on the side. I'm going to take these in the order in which they came. We haven't pre-screened them, as you will see, I suspect. Well, while you have the Constitution out of your pocket, this question is, what role do you think principles of morality have in the process of constitutional interpretation?
Well, certainly in law, morality has a role in the senses of, I asked this morning, the criminal law, for example, is based on principles of morality. That doesn't mean it reflects them perfectly, but it does mean if you find that a person has been convicted for what morally you would consider doing the right thing, there's something askew here. And it tries to make those things congruent. It doesn't always succeed, but that's a goal. And certainly you can look at the forms of government as embodied in the document, the basic things I mentioned, as moral points as well as practical civil points. And pretty soon, when you start trying to figure out how our human beings live together in a society successfully, you try to work out systems of law, and we try to work out some that might more or less work and allow them in a legitimate way, without people having authoritarian power over others, to reach better working communities. Is that a principle of morality or a philosophical principle of law? I don't know. But I think they're connected.
You know, you were talking a minute ago about the framers' desire to have citizens participate in public life, and that wonderful quote from Pericles. This question, I think, picks up on this in an interesting twist. It says, what is your opinion about the growing demand to televise the Supreme Court to provide the general public with access to the decision-making of judges?
Yeah, I can tell you the issue, and I can tell you why I don't think it'll happen too soon. It'll happen eventually, because eventually you'll have judges appointed who've just grown up with this and they can't understand why it shouldn't be there. But the issue for us who haven't grown up with it is the following. On the one hand, if we could have in the oral argument a television camera, most of the time, I think 90%, what people would see if they saw this whole oral argument is that they would see 9 people struggling with pretty difficult problems. And they'd soon come to the realization that there are 2 sides to these issues, even the ones you think are most one-sided. And you'd listen for a while, and I think they'd learn something, and that would be a plus. So what's the negative? The negative is oral argument is about 3% of the whole thing. We get most of our stuff in writing. And oral argument's very brief, and people identify with people. And they'll see a good side and a bad side. A good lawyer and a bad lawyer, a good client and a bad client. And we're writing our opinions for 311 million people who are not in that room. I mean, the law, as far as we're doing it, you're writing for all the citizens of Massachusetts and maybe beyond, not the 2 people who are there. And that's the job of an appellate court and our court, and people won't get that. And that's a risk. But I think mostly if you really something very, and you get different views on this, when they start putting it on television, I say, it's not going to affect me. You know, we have the press there anyway. If they want to distort things, they'll distort things. So what? In Canada, it doesn't cause a problem. But some pretty knowledgeable people in the press will say, wait till you see the first time that they take a soundbite and they put it on the popular program, And they make you say, with a scowl, the exact opposite of what any sane person would have thought you said. And you think it's tough to do that? No, it isn't. They're experts. And first time you said death penalty thing is all right, there you are, torquemada. And you see, they will affect your opinions. Or you'll keep quiet and won't ask any questions. And we don't know. The answer is we don't know. But all of us are conservative where the court's concerned. We are trustees for an institution that, by and large, has served the country pretty well. So I'll say we're nervous about it. And probably that's the most favorable you'll get. I mean nervous, uncertain, not aware of what's going to happen. And as long as we're uncertain, it's tough. And it works in lower courts, but I used to be totally for it when I was on a court of appeals. I said, why not let in the press? Who cares? Besides, they'll never come. Perfect. And the press is there, of course. Our opinions are open. They explain everything. There isn't really a secret part. It's really the conference where we discuss things frankly. So there you have some of the pros and cons. And as long as we're feeling that there are these pros and cons and nervous about what it would do to the institution, you're going to have an uphill battle getting us to do it. And I think I'm being honest in saying that's what I think the problem is.
I have to say that the Supreme Judicial Court has its oral arguments televised, and
Doesn't matter.
it doesn't matter, but it's very helpful for people in the far part of the state who can't get into the justices. It's very helpful because of the way you can now, if you've got a particular case coming before the court, you don't have to go and watch and sit there with all the cases. You can go back and you can anticipate. Not everybody practices every single day in the United States Supreme Court, the Supreme Judicial Court. But the best reason that I ever saw reference to about why it was good to have cameras in the court was as an advertising technique for one of the lawyers who appeared, who said, if you don't think I'm very good, go look at my argument in the Supreme Judicial Court, and had it online as part of his advertising. So you could expect to see that as well, Justice Breyer.
Yeah, well, but we don't know. You see.
No, you
and
don't.
The pressure that I think in growing is a tremendous tendency to try in the public mind to politicize our court. See, if I said there were 3 errors, I think the 3 errors are: 1, people don't understand that 98% of the law is state. I think error number 2 is they think the way we select cases is just take this case because, it would be so interesting or fun, that we have a wide range of choice in what we hear. We don't. We normally take a case because the lower courts have come to different conclusions on the same question of law, and that's a pretty rigid practice, and it determines most of what we take. And the third mistake, I think, is, I see what you really think. You think we're junior league politicians. And there I say, and I will say that the 50% are unanimous, our decisions. The 5-4s are about 20-25%. Hardly anyone knows that. And it's not always the same 5 and same 4 by any means. At which point, the students who've asked the question will say, yes, that's true, but those aren't the really important cases. I'll say, you're wrong about what's important and what isn't important. But still what you mean is those aren't the big sort of political social issues. There you're right. And on those, aren't you a junior varsity politician? I say no. She said, well, of course you'd say no. I said, well, look, it's how can I put this? These questions are often open, at least the first time. The word liberty in the Constitution doesn't explain itself. The freedom of speech doesn't tell us exactly what is included and what isn't. Those are open questions, often. And if they aren't, what are they in our court for? And in your deciding that, and you're deciding how these values and words written 200 years ago apply to today's circumstances, George Washington didn't know about the internet. So how does the First Amendment apply there? I made that brilliant point to Nino Scalia when we were talking together. He says, I knew that. Anyway, that's a different story. But of course, your background, Lowell High School, maybe 1950s, maybe my career, whatever it's been. The fact that I've been in law, as I have. By the time you reach a certain age, you have views. How does the Constitution relate to the public? What's law about? And people have different ways of looking at that. Of course that will affect you. If that's what you mean by politics, rather than is Senator Kennedy or Senator Hatch popular or unpopular, the vote goes Democrat, where are the votes? That used to be the Judiciary Committee. Who has the votes? That's kind of politics? No. Politics in the sense I've talked about? Yes. You can't escape your own skin. You can't jump out of your own background. Okay? I accept that. And I say we have a court that changes very, very slowly. Different presidents appoint different people. If they think they're going to appoint somebody who agrees with them all the time, they're pretty wrong. Teddy Roosevelt appointed Oliver Wendell Holmes. 3 months later, he dissents in Northern Securities, a big antitrust case, which Roosevelt would have said was, don't dissent. Roosevelt says, I could carve a judge with more backbone out of a banana. He was really annoyed. Don't expect the judge to agree. But on the level of very general philosophy, what the country, the court, the way law interacts with people in this country, values, they're more lucky. They're not always right, but there's a greater tendency. So slow change, different presidents, over time, people disagree on some things like that. Not surprising. Nor in a country of 311 million or 12 million people where there's every race, every religion, every point of view. There is no view so crazy, said my mother, that there isn't somebody who doesn't hold that view. Everything imaginable. Okay? So it's not so terrible that not everybody agrees with me all the time. Okay? Now, do you see? Do you get a picture? And it takes time to explain that picture. And see if you get that picture out of the press. Sometimes you do. When they're well written, you do. And sometimes you don't. But I'm trying to give you a little bit of in your own mind, compare what I've just said, which I think is pretty accurate, with the picture you get in the popular television, for example, often, not always. And now you get a sense of the pressure that we're under not to further this idea that it's political. Because if it is, why have us? Why not have Congress do it? They're better politicians.
Good question. Good question.
We haven't actually touched on judicial philosophy and judging at all, really, in a direct way. And this question I like because it starts off in the following way. Justice Breyer, you are my favorite Supreme Court justice.
Well, she might not know me very well.
Sounds vaguely political, actually, because of the consequentialist reasoning you deploy in your legal opinions. I struggle, this person says, with the disconnect between law, policy, and reality on the ground. How do you see the Supreme Court moving more in the direction of making connections between law, policy, and on-the-ground reality?
What do you think? I don't think those things can be easily separated. Do you?
No. No. You know, I think I want to return to one of the points that I heard earlier expressed, which is we answer the questions that you ask, right? We don't answer hypothetical questions. If you don't ask us the questions, we can't answer them. You know what is happening on the ground. You know whether or not there might be a legal answer to it. You know what is best for your clients. We don't. And the only thing that we have to do, the only thing you have to do as a judge is decide, or decide not to decide. But we can't send it to committee. So, you know, Justice Breyer talked about the internet. I mean, am I on Facebook? No. Am I on LinkedIn? No. Are my grandchildren on Facebook? Yes. Do they read email? No. My emails, the way I communicate with my grandchildren is text, read your email. Right? Because if you would like to see me texting, this is how I text. Right? And this is how I do email. So guess what? Read your email. And about 2 days later, I get a reply. If I text them, coming to dinner. Well, first of all, I can't do that because I can only say, are you coming to dinner, comma, tonight, question mark. Right? So you, no, it's Y-O-U. Any case. So there are other kinds of questions. For example, think of the questions that are also technologically based, which is husband and wife in those days decide to go to a sperm bank to freeze the sperm so that over time they think they might be able to have a child. They have a child with the appropriate technology, then husband and wife get divorced. He goes to a different state, and she is in Massachusetts, as it happens, and she goes to the sperm bank and says, give me one of those sperm, because I would now like to have a child. Why? Because she's reaching the age of 40, and even she recognizes that there's some limit on the amount of time. And the sperm bank has a contract that's signed essentially between the bank and the two parties on the other side. So what do you think they do? The bank phones its lawyer. What are we supposed to do? That's where you come in. Right? All of you. You have to advise your client. Client is really smart and says, I don't have a clue. Why don't you toss it to the Supreme Court, Massachusetts? Thanks, I say. Now, what am I supposed to say? Would I like to have legislative hearings? Would I like to know something about what's going on? Answer, I'd love to. I mean, we can say, this is a political question, we don't decide those, but I mean, really, please, they've just got a problem here. So you have to decide. But the lawyers have to help us decide. How do we answer that question? Can I take a little bit of your time? Sure. You say to your very smart law clerks who come from good schools, find out what the other courts have been doing around this country. Very smart law clerks come back and say, they haven't had this question. Rubbish, I say, for heaven's sake. Somebody must have had this question. So I don't know, Tennessee, doesn't anybody have this question? No. What do you think the next thing I do is? Go and find out what other courts around the world are doing. As precedent, Justice Breyer? No. Which courts, Chief Justice Marshall? Interesting question. Which courts? Try Canada, I say. Why Canada? Oh, I don't know. Try Canada. It's written in English, and they have got a constitutional. And, oh, by the way, see if Israel's done anything. Why? Well, because Judeo-Christian origins. Who knows? I don't have a clue. Law clerk comes back and says Israeli decisions haven't been translated into English. Oh, yes, they have been, I say. Well, it turns out the Israeli Supreme Court had decided the precise issue. Precedent? No. Helpful? Yes. Turned out that we were in alignment with the Israeli Supreme Court, but the court changed its mind afterwards. Now we're different. How did we decide? If you're going to be the father with all of the responsibilities that we impose on fathers, you have to have the father's permission. Correct decision? Who knows? Who knows? New York Times yesterday, front page, issue. State courts are deciding surrogacy issues completely differently. It's a mess. State courts. Where do you think it is going to end up?
No, why? We're not good on family law. We rarely have a family law
Did you
case.
hear that? Ask him which way he voted when they had grandparent visitation.
We never,
rights.
well, that was, but we're not good at it. and we shouldn't be. It's state court. And the things that I paid close attention to what Chief Justice Marshall said, because there are a lot of things in her answer that are interesting. One, matters of great importance and uncertainty with new technology affecting families, for example, and not the only thing affecting families. It's the states that will decide it. It will not be us. So I would take that in. Second, think of how unusual her case is. I'm a judge. Judges decide all kinds of things, but most of them are things like, for example, when a railroad abandons a right-of-way, does that right-of-way go to the neighbors who is it a fee simple, or is it was it some kind of easement, and once it disappears the surrounding property gets it, or can it go back to the federal government, in which case they could turn it into a bicycle path? You know, those are hard enough, but they're not going to be on the front page of the paper, but at least they're law. And the question now, we're here next week, when somebody appeals from a criminal conviction, and he's in a habeas court, gets to the Court of Appeals, and it was the government that appealed, and he defended, but he wants to defend on a different ground than the government ever brought up. When can he do it, and when can he not do it? Those are hard enough. Those are legal questions. That's what judges do. They sit and decide questions of law, which are hard enough. And these great things like the sperm bank, or even like privacy with the stuff that goes on, don't come to us first. Now, who am I talking to? I'm really the person who captures it's Tocqueville. He says when he comes to America, he hears a big clamor. What's that clamor? It's everybody arguing. They argue. Good. I mean, shouldn't get too violent, but they could argue. Argue in law schools, argue in journals, argue all over the place. Try it out. Try it out in an administrative process. Try it out with an administrative rule. If you don't like it, change it. Try it out in a legislature. Try it out, as Brandeis said, in one of those 50-state experiments. Try it out here or there. Let Congress pass a law. It didn't work. Withdraw it, etc. Then, when things settle down, and then let the Supreme Court decide whether whatever you came up with exceeds the very broad boundaries of permission that the Constitution sets. Because what this document does is it does not tell people what to do. What it does is it sets outer limits on what governments can do. And I usually think of it, I used to listen to a program years ago called Sergeant Preston of the Yukon. Sergeant Preston was on the radio, and what he did was he patrolled the frontier. He was Canadian, and life on the frontier in Canada is tough. In the winter particularly, it's cold, and is abortion inside the frontier or outside? Tough. Is, your case, or is it over here or over there? Tough. But it's the frontier. And what people are forgetting far too often is that in deciding whether a solution reached by others democratically is beyond the frontier, that's rare, and it is not the heart of the matter. The heart of the matter under this document is that people in cities, towns, states, and their communities get together and they decide through a democratic process what kind of cities, states, towns, etc. they want. And call us in when you want Sergeant Preston. But we hope that won't be until later, until we've learned something, had time to see it simmer down, have records to go to, see what worked and see what didn't work, and then maybe we'll get it right when we tell you whether the solution reached by others is beyond the frontier.
So I think we've come to the time for our final question. And while you still have that Constitution out of your pocket, or almost, maybe this is a good one to end on. What, in your view, is the chief deficiency of the U.S. Constitution?
What's your view, Mark?
They never asked the psychologist. I'm very thankful, actually.
No, go ahead.
No, I have no view.
While we're waiting for Margie, what is your view as a psychologist?
No, what I was, I love the United States Constitution. I admire the justices, all of the justices on the United States Supreme Court. I really do. I came from a country that didn't respect the rule of law. I grew up where the law was anathema to everything that I believe in, and I hope that everything that you would believe in. The Massachusetts Constitution begins with the Bill of Rights. It embodies what is put into the structural framework of the federal, but it begins with the words, all people are created equal. Actually, that was modified by the good citizens of Massachusetts in 1972. It used to say, all men are created. It's now all people. And there is something extremely liberating when that's your starting point, as opposed to Congress shall make no law. And so I don't think it's what's missing, and I think it underlies why matters have developed in a way which might be a little different. And if I can take just 1 minute to say what the difference is, the very, very first case that came to the Supreme Judicial Court of Massachusetts in 1782, which was, the Constitution was adopted in 1780, was a case as a challenge to slavery. People forget that Massachusetts had slavery. Massachusetts had slavery. And it was a challenge by a slave to this new Constitution. Who were the justices on the court? They were the sitting justices. Appointed by who? The governor. Who was the governor? The king's representative. These were not revolutionaries. But they did, in essence, what Justice Breyer has talked about. They took from their pocket this new Constitution, only it was a rolled quill pen, and they read, all men are created equal. And if you look at the notes of Chief Justice Cushing, he then was, they are very simple. Your skin has a different hue, your nose is flat, and your lips are wide. I'm not making this up. But you look like a man to me. End of slavery in Massachusetts, 1783. That is a great document. And I would love you all to read the United States Constitution, to carry it around in your pocket every day, not just the 1st, the 4th, the 5th, and the 14th, not just the 2nd and the 9th, but Article 1, Article 2, Article 3, Article 4, because you have great documents here. The newer constitutions, like the South African constitutions, have different provisions. Which are the ones that they now have? Justice Breyer has alluded to one. Privacy. We don't have a specific provision. What does that mean? I don't know. Privacy. That's an important one, and we have to wrestle with that.
Yeah. It's funny, I made the joke about being a psychologist, but and Justice Breyer said, well, what do you think? And the thought that occurred to me is, as a psychologist, I wish the Constitution had something to say about privacy and such, because those are the issues that face us.
You have to persuade us. You have to persuade us how to wrestle with those issues where the Massachusetts Constitution doesn't talk about a right to privacy, and the United States Constitution is.
Yeah.
I don't think it's not perfect, the Constitution.
We should give you the final word, Justice Breyer.
No, this is a bad final word, because this is just a footnote. I mean, of course I don't think it's perfect. It isn't. There's no such thing as human perfection. And second reaction is I'd like it to incorporate all my dissents, and then it would be a much better document. But I think my reason of hesitating is because I would be afraid to open the door to a lot of amendments. I don't know what would come out of that bag. And it might be the things I like the best would disappear, and the things I like the least would suddenly appear. Dangerous thing. It's very hard to amend our Constitution, and I think that's a pretty good thing. We'll live with it. And what do I want to... Final word? I've already had 19 final words. Final word? Yeah, you said read the document and try and think about it. And if I would take one message away from it, it is it puts the responsibility upon you. It's you, it tells. Teach them on the next generation. Tell those next generations, and that means you tell your next generations too. And it goes on. What the country is about, what the Constitution is about, why it isn't just an object of worship that people do. It helps hold the country together. It does, even if they don't know what's in it. It does. And knowing what's in it is even better. And if I wanted one word, it would be participation. That it foresees. And you say, oh, I hate what the government's, and the cynicism that is flowing is really reason to press that point of participation. You don't like what's happening? Well, persuade some others. That's the system they find. It's called the majority wins. Not perfectly, it doesn't work perfectly, but there we are. Nothing does. So that is, if it's a message, it's a 4th of July message, and this isn't the 4th of July, it's the 17th of September, but it's the same thing.
Please join me in thanking Justice Breyer.
Thank you so much. Thank you. Yep. Thank you. That was terrific. Great hour. Thank you.
Thank you.